Here to talk about estate planning, and not only estate planning, but how you can have evidence in the form of film that can further somebody's intent as to who they want to leave their property to. Estate planning is nothing more than having a way to dispose of your property, not only during your lifetime in order to make gifts, that's estate planning, but also the property that you leave when you pass away. Now that takes the form of just having a basic will, a minimum of basic will, but it also includes living trust. But there are many situations where it's not so smooth. You have people who are married, this is your second or third marriages for these people, and they have blended families. We have a good friend who has 5 children from different marriages. And we talked to him about having a video will, and he goes, I don't need no stated video will. Nobody's going to contest my estate plan. Well, but it's important to know that there are 3 fundamental issues whenever you deal with an estate plan. And those 3 fundamental issues are undue influence. Somebody may be unduly influencing somebody to leave their estate to somebody, and they're under duress, coercion. And this happens to people who are over the age of 55. And according to the state of California, once you turn 55, you get a free meal at Denny's. You get your Grand Slam breakfast at Denny's.
I didn't know that.
But you also are presumed to be subject to undue influence. It's in the code. Once you turn 55, then you are susceptible to people trying to influencing you to leave your property to other people. So it's one of those issues you have to watch out for. And I have seen many situations, I've been in trials where we would have somebody, for instance, who had family, but the family ignored her. And what she did is that she became really good friends with her caregiver and her gardener, both of whom were married to each other. So what she did was she said, you know what, the heck with my family, I'm going to leave my property to my caregiver and her husband, the gardener. So we had a trial on the issue for 6 months to determine whether she was unduly influenced. This woman was in her 80s when she gave her trust, when she died. She thought she had the right mind to leave it to the gardener and the caregiver, but because she set up this document, there was a presumption, being over the age of 55, that she was susceptible to undue influence. And sat down with a video camera and said, hi, I'm Jane Doe. I may be in my 80s, but I've got my wits about me. You can ask me any question you want to judge my capacity. And there's a mini mental exam that they give, a battery of questions to determine capacity in that situation. The second level, as I said, is mental capacity. Incapacity. Is this person capable of understanding what this person has and who they want to leave it to? Video wills are becoming more and more acceptable in courts as far as a way to proving capacity, proving the fact that there's no undue influence. And capacity takes many different levels. It is, being in a vegetative state, or not knowing exactly what they have, not knowing who the objects of their bounty are, their natural heirs, and just not knowing specifics as far as who they want to leave their property to. So incapacity, or mental capacity, is an essential issue to determine whether this person knows what they're doing when they set up a will or a living trust. The great thing about having a will or a trust or any other document is that it's all there on paper. You can say, look, that's my estate plan. It's there on paper. I know exactly who I want to leave it to. But sometimes that doesn't really capture what that person wants to do because of either poor draftsmanship, capacity, understanding of exactly what's going on with that. When you have a video will, what you can do is you can sit the person down and have them answer basic questions about what they have, list their assets and their liabilities, who their family members are, and then who they want to leave their property to. So having a video will is really essential in that area. And the third aspect of it, of course, is fraud. Fraud in the sense that somebody got a document in front of them, purporting to be their last will, and somebody else signs fraudulent signature. Or it's a situation where there is, they're not aware of what they have. They think they have assets of this amount, but they don't. Or they think they know who the objects in their bounty are, and they're mistaken. So a video will help to kind of bust the fraud issue, at least minimize it and help prove a case for having a will or a trust legally and validly admitted to probate. So those are issues that we all have to think about and deal with. I come to you with 20 some odd years of drafting documents on paper. But now we live in a very digital age. You know, we've got YouTube, we have many aspects where things are being streamed, and it's becoming part of the legal lexicon to offer evidence in the form of videotaping. And videotaping is such an arcane term now. It's like some 70s, you know. But it's a way to make sure that you have your wishes documented, not only on paper, but used as evidence from the grave. So that if somebody has passed away, you have at least a video record of exactly what they want to do.